What's up everyone, it's the Law School Lumberjack here again with another video. I hope you're doing well, and today we will be doing an installment of our Property Law 101 Fee is Not Simple series. Specifically, we will be looking at two types of co-ownership, joint tenancies and tenancy in common. So today we'll go through the two types of co-ownership, what the general rule is at common law, as well as what's called the four unities, which are required in order to make a joint tenancy, and should one of those unities fall away, it's sufficient to sever the joint tenancy. So without further ado, let's discuss tenancies in common. So a tenancy in common is generally what we think of when we think of ownership of property. When you think of, let's say, going into a business deal with someone, or when you think about entering into a contract with someone for an asset, generally, unless they're family or there's maybe some estate planning purposes, you're thinking of taking a percentage of that asset and have a percentage right to that asset. Another function of the tenancy in common is that parties do not have to own that same percentage. So you could have a party who, on title, for example, to real property, owns 99% of that property, with the second party only owning 1%. Additionally, as I know in property law, estates come up quite often. With estates and estate planning, what happens when a party has that tenant in common interest or a percentage interest in property, when they pass away, that percentage interest is transmitted to through their estate to their beneficiaries. So if a party has, let's say, a 99% interest in real property, that 99% interest goes through the estate and gets passed on to the beneficiaries. Now, conversely with joint tenancy, multiple parties own the property jointly. So in other words, they have a right to the whole of the property, and should their interests ever be severed, they have to have an equal interest in the property. Now, one of the most powerful and important elements of a joint tenancy is the right of survivorship, which is why you see oftentimes a joint tenancy in situations with estate planning purposes. And what the right of survivorship is, it's a right that upon the death of one of the joint tenants, their interest automatically gets vested in the remaining parties. So for the sake of simplicity, in an example, let's say two parties, let's say Amy and Bob, are married and they purchase property jointly. If Bob dies before or predeceases Amy, the right of survivorship kicks in, and Amy then beneficially owns 100% of that property because Bob has passed away. Now let's compare that to a situation where there was a tenancy in common. If Amy owned 50% of the property and Bob owned 50% of the property as tenants in common, then if Bob passed away, Amy would still own 50% of the property, and Bob's estate would own his interest in the property, which would then get passed on to the beneficiaries. So things like probate checks, potential wills variation claims, and things like that make it very beneficial when it comes to estate planning in certain circumstances to have that right of survivorship. Now that we've gone through a fairly lengthy definition of joint tenancy and tenancy in common, let's go through the default when it came to the common law. At common law, it was assumed that parties bought property as joint tenants unless a contract suggested parties were wanting to buy as tenants in common. So some words that were in contracts that suggested the parties weren't buying it as joint tenants were words such as equally or a different percentage, so 1/3, 2/3, for example. Those suggested that people were buying as tenants in common because, again, joint tenants own the whole of the property together, not percentages of that property. Now, certain statutes in certain provinces have changed this default or this assumption such that it is assumed that property, if bought by more than one person, is bought in a tenant in common situation. So, for example, under the Property Law Act in British Columbia, it's presumed that if multiple parties are buying real property, they are buying as tenants in common, unless the contract states otherwise. And so, for example, when a party's buying personal property together, it's assumed to be as a joint tenant, and when people are buying real property, it's assumed to be as a tenant in common. Now, this does not only exist in British Columbia, there are other provinces and other statutes which shift that assumption in different provinces, but that is just one example. Now, as I said previously in my introduction, one of the defining characteristics of a joint tenancy, or something that is required to create a joint tenancy, are what's called the four unities. And you can imagine the four unities as kind of four pillars that are necessary to have a joint tenancy constructed. So the four unities are this: the unity of possession, the unity of title, the unity of time, and the unity of interest. The unity of possession suggests that all co-owners in a joint tenancy have the right to possess the whole of the property throughout their duration of the ownership. This is also known as being entitled to the undivided possession of the whole of the property, if you hear that in your property law class. Now let's go on to the unity of title. So the unity of title requires that all co-owners derive their legal interest in the property from the same instrument. So when it comes to transferring land, for example, or people buying land as joint tenants, all parties or all co-owners need to show up in the title transfer document. Now we come to the third unity, being the unity of interest. And this presumes or requires that all parties have an equal interest in the joint property, but also that their interest must be of the same quality. Meaning that, for example, if one party has a legal and beneficial or an equitable interest in the property, the other co-owners have to have the same. So I'll get into severing a joint tenancy later in this video, but for example, if one joint tenant mortgages their interest and gives up the equitable interest in their property or the beneficial interest in their property to a mortgagee, that arguably would sever the joint tenancy, because not all parties or not all co-owners have the same type of interest as that party who has now mortgaged their interest, assuming that the other co-owners have their interest mortgage-free. Now the fourth and final unity is the unity of time, which requires that all parties' interest in the joint tenancy vest at the same time. And one example where this wouldn't happen is a situation where people are given their entitlement to the property at different times. So for example, let's say Charlie owns property. He passes away, and in his will, he wants to give his property jointly to his children once each child turns the age of 21. Now let's say one party's older than the other and they aren't twins. Because one child will receive his interest earlier than the other child, it is not possible for this property to transmit as a joint tenancy, and it must transmit as a tenancy in common. So in a law school exam, if you're trying to argue against a joint tenancy, what you want to do is first consider what the default position is with respect to the property and co-ownership. So where you're in a situation where property is assumed to be bought as tenancy in common, you just have to make sure that nothing in the instruments suggests that a joint tenancy was intended. However, if you're in a situation where either the contract suggested that the intention was for joint tenancy, or you're dealing with property and you're in a jurisdiction where joint tenancy is assumed, what you then have to do is try and look at each of the four unities and see if any of those were broken at the time the joint tenancy was vested. So what you have to consider is first, let's say, for example, the unity of title. You look, was everyone included in the same instrument? Were all co-owners included in the same instrument? When it comes to unity of time, did everyone's interest vest at the same time? When it comes to the unity of possession, is everyone under the contract entitled to an undivided right to possess the whole of the property? And finally, fourthly, did everyone have an equal interest in the property of the same type? So was someone's interest mortgaged when someone was not at the time the interests had vested, etc.? So if you've done all this and have satisfied yourself that the joint tenancy was validly created or the unities existed at the time of vesting, the last thing you have to ask yourself is, was there some subsequent fact which severed the joint tenancy? So you can think of the four unities as kind of legs of a stool, and all four have to stand for the joint tenancy to exist. So if you knock out one of the legs, the joint tenancy crumbles. So you need to look at the subsequent facts to consider whether or not one of the unities has been taken away. Now, I won't go through an exhaustive list of things that can sever a joint tenancy, but here are a few examples. So starting with the unity of title. If someone successfully sells their interest in the joint tenancy, then that breaks the unity of title because all parties' interests are not based on the same transfer documents or the same instrument. The initial co-owners, Party A and Party B, were on the same instrument, but if Party B sells his interest to Party C, that's a different instrument. So that knocks the unity of title out, and we have a situation where each party now owns the property as tenants in common. Regarding the unity of interest, I've already gone into this, but let's imagine a situation where Party A and Party B jointly bought the property, but due to some financial hardship, Party B has to mortgage his interest in the property. By mortgaging his interest, the interest owned by Party A and Party B is not the same. This would arguably sever the joint tenancy into a tenancy in common situation because the unity of interest falls away. One final way to sever the joint tenancy is to partition the property. So what this generally does is it allows the court to sever the interest in the property and in a way subdivide the property into each party's proportionate share. I won't go into detail as to what partition is and the Partition Act, as that could be a video in and of itself, but just understand that partitioning could be one way to sever property. Hopefully this video helps explain what a joint tenancy versus a tenancy in common is. Hopefully it has provided some insight for your law school exam. If this video was helpful, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. Have a good evening.